Hi, everyone. My name's Elliot Butay. I'm the Criminal Justice Coordinator at NAMI Minnesota, or the National Alliance on Mental Illness. So I coordinate our advocacy efforts and public policy around the intersection of people with mental illnesses and the justice system. And we spent the last several years working on legislation we're about to talk about around what's called competency restoration. And our other presenters were also hard at work with us during that time. So I'll let them introduce themselves. Elizabeth, you want to go?
Sure. Thanks, Elliot. Hi, everybody. My name is Elizabeth Beltaos. I am an assistant Hennepin County attorney. I have been a lawyer for 36 years, and I have been in the Hennepin County Attorney's Office for 17. Before that, I worked in the Ramsey County Attorney's Office. And in each office, I have worked as a prosecutor, but I have also worked in the area of civil commitments, which is what I am working on right now. Nice to see you all.
Hi, I'm Katheryn Cranbrook. I am a licensed psychologist and forensic examiner. I am currently employed as the chief of the Regional Psychological Services Division and the Psychological Services Division for the 4th Judicial District, Hennepin County. I supervise a staff of about 24 forensic evaluators who complete evaluations of competence to proceed, mental state at the time of the offense, civil commitment, and a range of different psycho-legal issues that impact people that are involved in the court process in one way or another. And so I have been working with Elliot and Elizabeth on the competency restoration legislation and have a lot of investment in seeing this system improved for everybody involved in the process. Thanks for joining us.
Thank you. Well, I think Elizabeth's going to kick us off and just start with talking about what is competency restoration at all. So.
Yeah, thank you, Elliot. So we just wanted to give a really brief sort of history, if you will, of what the legal principles are behind competency restoration. And the legal principle really is really old, and it comes from England. But the principle is really that people have a right to a fair trial. And a fair trial means that the person standing trial has to first be competent. And this was recognized in 1960 in a United States Supreme Court case called Dusky versus United States. And it really laid out the framework for the requirement that a defendant facing criminal charges must first be competent before standing trial or pleading guilty or being sentenced. Next slide, please. Thank you, Elliot. So the legal requirement is that a defendant must be competent. And in Minnesota, that is found in a rule of procedure. It is found in the rules of criminal procedure, and specifically Rule 20.01. And the language in Minnesota's criminal rule is taken from that 1960 United States Supreme Court case. And what it says is that somebody must be able to rationally consult with their attorney. They must be able to understand the proceedings and be able to participate in their own defense. Now this slide we were talking as we were getting ready to present about how this slide perfectly represents what the current system looks like. This slide is a really busy slide that has arrows and different directions, and that is part of the problem with the current system that we're going to talk a little bit about. But the current system starts in the criminal justice system when a defendant is charged with a crime and goes to court, and there is a motion made, typically by the defendant's attorney, that asks the court to order an evaluation of the defendant to determine whether or not the defendant is competent to stand trial. So part of this, what this slide shows, is the intersection of the criminal part with the civil commitment process, because the current system links the criminal justice piece to civil commitment. And as we're going to talk about, that's been part of the problem with the current system. But a motion to evaluate a defendant's competence can come at any time during the pendency of that person's case. It can come at the first appearance, first time that the defendant appears in court. It can come at the second appearance, the third appearance. It can come at trial. A motion can also be made at the time of sentencing. A motion can also be made after somebody has been convicted but is facing a probation violation, revocation. So the motion for competence can come at any time. And Elliot just put a note in the chat to unmute and feel free to ask questions as we go along. So that is really what this shows. When a motion is made and a defendant is found incompetent and the finding is issued by a judge based upon an evaluation report by Dr. Cranbrook or another forensic examiner. If a finding of incompetence is made, at that point, the case in the criminal system is suspended. And if you will, it travels over to the civil arena for referral for possible commitment. Katheryn, I'll turn it over to you at this point.
Great. So the Rule 20, as it has been, the competence evaluator is doing an evaluation of the individual's competence based on the criteria that Elizabeth laid out, and will offer an opinion about competence, but also they offer an opinion about whether or not the person is an appropriate candidate for consideration of civil commitment. And so the examiner will offer an opinion about whether or not that person may have a mental illness or a developmental disability that warrants intervention in civil commitment court. And if that is determined to be true, then the case first goes to pre-petition screening. Pre-petition screening is typically a county organization staffed by mental health professionals who have expertise in assessing both assessing mental illness, chemical dependency, developmental disabilities, and also looking at possible risk of harm to self or others. The pre-petition screening team takes a look at the case because in order for civil commitment to proceed, the individual under consideration has to have both the pre-existing condition of a mental illness or developmental disability. Those are typically the prongs in a civil commitment case stemming from an incompetence finding. They also have to be at some risk of harm to self or others that overrides their independent rights to determine whether or not they want mental health treatment. So for most of us, we have the right to decide if we want or don't want mental health treatment. But in civil commitment, the process is questioning whether or not that right to decline mental health treatment should be overridden for public safety or due to risk to self or others on the basis of mental illness, chemical dependency, or developmental disability. So pre-petition screening takes the first look at this, and they may interview the individual, maybe collateral people in their lives, family members. They review relevant medical records and the criminal complaint or police reports, and ultimately make a preliminary decision about whether or not they think that the commitment should go forward. Now, if they do not yield a decision saying that this person is committable, so to speak, or appropriate for civil commitment, you will see that the arrow goes down to the bottom right corner to the red box that's called gap cases. And these are cases in which an individual has been found incompetent due to mental illness or developmental disability, They've been referred for civil commitment potentially, but for one reason or another, there is no mechanism for ensuring that they get mental health treatment or that they are restored to competence. So the first kind of off-ramp from civil commitment is at pre-petition screening, where the civil commitment process may or may not go forward. If pre-petition screening says, yes, this person does meet criteria for civil commitment in their kind of initial opinion, then it goes forward and a petition is filed. The individual gets an attorney in the civil commitment process. County attorneys represent the government, and a forensic examiner is appointed to do a neutral evaluation and offer an expert opinion on whether or not the person meets criteria for civil commitment. So the examiner will look at similar information to that of pre-petition screening. They will look at mental health history, symptoms, risk to self or others, and they will ultimately make a determination whether or not they support civil commitment or not. This is another place where if the examiner says, no, I don't think that this person meets commitment criteria, they can gradually make their way down into the gap cases box, where again, there may not be a means for any kind of mechanism to ensure mental health treatment or restoration to competence. I can say that clinically, many of the people who move forward to the commitment process but do not meet commitment criteria, it is because of the lack of risk. So they may have a mental illness or developmental disability. They may have that pre-existing condition, but there is not evidence of risk to self or others such that it is considered appropriate to override their individual freedoms and force mental health treatment over their desire not to receive such treatment. If the examiner does support mental health commitment, civil commitment, then a second opinion can be sought, a trial may happen, and ultimately the judge will determine whether or not there's adequate evidence to civilly commit the individual to court-ordered treatment services. For most people who are in this process as a result of a finding of incompetence, they may be in the jail, they may be in a hospital while this process is happening. If it's serious charges, they're probably being detained in the jail. For less serious charges, they may or may not be in a hospital. Sometimes they're in the community, but that is less common. Once they're civilly committed, the judge can order their mental health treatment, which may be inpatient psychiatric hospitalization. It could be an array of different levels of service, depending on what is needed. But if it is deemed appropriate that they be committed to an inpatient setting, they are supposed to be transferred from the jail to the inpatient setting within 48 hours. We have a 48-hour rule, or had a 48-hour rule, I guess. We have, this has been a big point of difficulty over recent years because of a lack of hospital beds. Generally, people weren't being transferred from the jail to the hospital within that 48 hours. So that is one of the reasons that we are really looking at, we're looking for the new legislation and are looking for positive changes. Once the person is ultimately committed to a hospital setting, they can receive their individualized treatment. They may need psychiatric medications to address their condition, and that would happen through a separate process. It's called a Jarvis order, where they can be ordered to take medications. In any case, the hope is that they achieve psychiatric stability, and at some point, when they no longer need hospital level care, they are provisionally discharged. So they are still under court supervision, but they are no longer in a hospital setting. They may be released to a group home setting, their own home, chemical dependency treatment. It depends on what the treatment team thinks is appropriate. Years ago, the hospital typically maintained people in the hospital setting until they had achieved competence to proceed, the legal standard. Over the last couple of years, that has not been the practice. Again, due to bed shortages, individuals are discharged once it has been determined they no longer meet the need for hospital level care. So the hospital determines when they don't need to be in the hospital, and whether or not they have been deemed competent to proceed, they are discharged from the hospital setting. They can be discharged, as I said, to the community. If they're a person who came from jail, they may be discharged back to the jail setting for the court to determine what the next step should be in their process. Oftentimes in those situations, they may not yet be competent. They've been discharged from the hospital, and they may be back kind of in that gap in terms of not yet competent. They are under court order to participate in mental health treatment, but the intensity of the services may have stepped down because they no longer meet hospital level care. I did see a question about the realistic length of time. I think that yes, it can be months. I don't know what the actual wait time is for DHS. I do know of cases in which people have been maintained in a jail setting for a couple of months awaiting a hospital bed placement. So I think that's back to you, Elliot.
Yeah, and I give a little bit more context along all of this process. That's a good question, Ash, and the timelines and all these aren't really here, but one of the, a lot of the reasons why we really wanted to address the issue was that, from, like number 3, the competency motion, to the examination, to the determination, those are obviously ordered by the court, but they're not quick processes generally. And, Dr. Cranbrook could talk about the shortage of examiners that we have. And so it is often difficult to get a person scheduled for an examination. And then there's also an issue where some people are in jail. And so that's an easy way, or they could be ordered to a treatment facility, which we've already, discussed we're short on, or they could just be in the community. And that means that person who right now we're questioning, their legal competence, and we're probably acknowledged that they have some sort of mental illness or are, struggling with that. It's their responsibility to go to the examination. And we're also talking about a lot of people in this process who may be homeless or might, be struggling to meet their own basic needs. And so if they don't make it to their first exam, they get put into another list of, a waiting list it kind of resets that process where they have to, show up for another exam. And so this process at the top can also take months. And so I wanted to point that out. Yeah, I think that was, I probably had other thoughts, but I'll keep going. Did you want to say something?
Well, I just would add that, yes, there's a huge problem both across the state with a lack of forensic examiners. And so finding examiners to take the competency evaluations is difficult. There's also a big problem with follow through, especially because as you mentioned, people are mentally ill, they may be homeless, whatever, they may not follow through with examinations. And the other thing that it was noted in the chat was wondering how many of our examiners are BIPOC individuals. I would say it's a small percentage in the state that are BIPOC individuals. That is certainly an issue that is always under consideration, and we attempt to recruit. In fact, within my department, we started a postdoctoral fellowship with the hope that we could recruit more examiners who may be going to school in other states and would try living in Minnesota for a year. And then maybe stay. But it's an area where we continue to struggle, although we are certainly aware of and attempting to recruit folks of color, and cultural considerations are always considered.
And I did think of the other thing, which is that the reason why it's separated from the criminal and the civil court, because there is that difference that we talked about between the legal standard of competency and this civil commitment standard. And so, even if a person is being, I guess when we talk about that, there's no mechanism, we're talking about in the Rule 20, it says when a person's incompetent, give them to the civil court, but it doesn't say, and then the court is responsible to restore them to competency and make sure that they go through with their trial. And it doesn't say DHS is responsible, it doesn't say anything right now. And so that's where the gap is. And so even if a person's getting treatment, it's not necessarily the same thing as being returned to competency. And that is, confusing. NAMI represents individuals with mental illnesses and family members, and that's confusing to use the word competent sometimes, because people might be, well, they're definitely not competent, right? But the court said they are, or they might say they are competent, but the court said they aren't. And that is just like legal language that is really specific to those things that Elizabeth talked about at the beginning. So just to kind of put that in context too.
there's a question from Jules about whether or not, I assume the current process is the question, whether or not anyone is required to assist them to help them get to their appointments. And under the current system, there is not. But under new legislation, there is. And that was a really big piece of the new legislation.
Yes. So I'll talk about that a little bit. So, you know, this has kind of always been an issue, that this court rule has been in place for decades. But there's been, since about 2013, just kind of an exponential growth of the number of people who have been, you know, examined and found incompetent. So, you know, year over year, it's growing and growing. So that's where it really started to put even more pressure on the systems. And that's where things like that 48-hour rule, that was passed in 2013. And I think that it was probably at that point seen as more feasible to get people out within 48 hours of the jail. But once we were getting hundreds of more people, that was not possible. And so this all, you know, kind of came to a head around 2018 or 2019. And so NAMI advocated in the 2019 session to create a legislative task force that would look at the issue. And it had 25 members, county attorneys, public defenders, sheriffs, you know, mental health professionals, people who had gone through the competency system, victims of crimes, and just many, many people who got around the table. And that met all the way until February of 2021. We had released an interim report and a final report that included recommendations and really laid out all these issues. And as we talked about, it's very complicated and there's not just one kind of easy fix. So the report and recommendations really talked about that. And I don't want to get out of order here, but I did think of one more thing on the last slide that is sometimes confusing about civil commitment and hospital beds. When we think about hospital beds, you might think that, oh, there's a hospital in my community. And, you know, we're talking about inpatient psychiatric beds, which are, you know, very specific. And, you know, they, you know, frankly, they don't make hospitals a lot of money. They don't make hospitals any money. Most hospitals lose money on the inpatient beds that they operate. And so there's not a lot of incentive for hospitals to have a lot. But the 48-hour rule is also very specifically talking about a state-operated facility, which is different than just your community hospital. So when a person is civilly committed, you know, outside the competency process, most people are actually civilly committed into the community. They go to a community provider and the court just makes sure that they're engaging in their treatment. These people, you know, since they have more serious charges or serious kind of situations, they are often committed to the state-operated hospital, which is a facility, the Anoka Metro Regional Treatment Center in Anoka, that has a number of beds. I can't remember the number right now, but they're all inpatient psychiatric beds, and they're all, so it's just a hospital dedicated, a psychiatric hospital. But that's the only state-operated facility, inpatient hospital that we have, really. The state operates some other ones, but we largely have a community-based mental health system. So in some other states, you know, they have other options because they have a lot more state-operated facilities and they can just put people in them. But you know, we actually, at least from NAMI's perspective, you know, think it's a good thing that the community be the ones that are handling our mental health treatment. But that does require the community and those, you know, hospitals and providers to step up. So I did just want to clarify that, you know, when we talk about hospital beds, particularly with this issue and people waiting in jail to go to the hospital, it's really specifically because there's not beds in the state-operated hospital. And when Dr. Cranbrook talked about the change from when they used to hold people until they were competent, and then they stopped doing that, that state-operated hospital was the only hospital that would do that. So if they went to a community hospital, there was no consideration for competency at all. So it's a little just confusing that there's mental health treatment and then there's competency restoration, like education and services, and they're related and they're necessary, but they're not the same thing. So again, hopefully not confusing folks too badly, but
And can I add one thing? The the treatment issue and the rise in competency referrals it's a national crisis, really. I mean, this is being seen across the country. This is not an issue like, individual to Minnesota. There are states across the country, every place that I talk to is having the same kinds of issues with not having enough examiners, not having enough treatment facilities. It's a major problem across the country.
right. And one question about, talking about what facilities are available. There's, a lot of the metro hospitals have some inpatient beds. We actually lost quite a few in St. Paul recently with the closure of St. Joseph's. So, there's a whole advocacy conversation about adding beds, but there's also other lower levels of care that might also work for people, like residential settings, which, we call IRTS facilities, intensive residential treatment services. So there's a continuum in the mental health system that can work for people, but a lot of people at this very most serious end of the spectrum do need an inpatient setting. And what we have is just not enough right now. And I could connect after about, where those facilities are. I can't off the top of my head think of those, but so these are really the complicated issues that we went over for almost 2 years in this task force, and finally released recommendations to the legislature. And after the task force ended, we really just tried to keep people engaged in actually writing legislation that would enact the recommendations. And so we did that, and then it was introduced this last session in 2022. And we had a huge bill, and everyone had looked at it, but issues keep coming up throughout the session. So Dr. Cranbrook and Elizabeth can both attest to the many, many meetings we had throughout the session, sometimes weekly, sometimes daily, really trying to agree to what would work for everyone. And I did just want to, speak to that. That was a difficult process, but also a really rewarding one at the end, because it is somewhat, uncommon for all of these stakeholders to come around and agree on something that's so big and such a huge change in the system. To have county attorneys and public defenders and providers and counties and, advocates agree was a really big deal. And so we're pretty proud of that. And we have to see exactly how it gets implemented, but it was really a struggle. And also, for people that don't know the story, it also passed the legislature with about 4 minutes to go in the session. So the legislative session is required to end on a certain date at midnight. And the bill was passed in the Senate at like 10 p.m., sent to the House, and then it was pretty contentious. It also included, which was not originally part of the competency bill, a $92 million mental health bill, which was awesome, but added to the hesitancy to vote for it. And so, yes, so 4 minutes left until midnight when the House passed it. And and if you also are familiar with the legislative session, it was one of the only things that passed because we didn't get much agreement on other things in the legislature. So
Elliot, if I can just jump into what you were saying, I completely agree with Elliot's description about how difficult this was and how hard all the stakeholders had to work. Weekends, vacations, people would check in during their vacations to join meetings. But this bill did enjoy bipartisan support, and that is really key. And I think that propelled this bill toward passage, is that we did have bipartisan support in both houses. So that is huge. So I just want to jump on to Elliot's comment. It really is rewarding to have worked for so many years on something that is so badly needed. So thanks for saying that, Elliot.
Yeah, and I think it'll stay with you, Elizabeth, to talk about the legal side of what the new legislation does.
Yes. And sorry, I'm distracted by the shiny bike of the chats that are popping up.
Yes, no, I can.
So the new process, which is going to start in July of 2023, the big piece that's different is that this is a statutory framework. That is huge because right now the process relies on a criminal rule, as I mentioned. And the criminal rule, as Elliot and Dr. Cranbrook have talked about, is connected to civil commitment, which is a different statute, and it's a civil process. So this new legislation is huge because it's a statutory framework. It's in one place for this. There's no traveling to civil commitment for possible referral in order to get somebody the treatment that they need. So that's the first thing I want to say. It's not on the slide, but the fact that this is a statutory framework is really key improvement. So the new process starts much the same way the current process starts now, where there is a motion made, again, typically by the defense attorney, asking that the court order an evaluation to determine the defendant's competence to stand trial, plead guilty, or be sentenced. What's new in this process is that as soon as a motion is made, the court will assign a forensic navigator. And that goes to the question that was asked earlier about whether or not there's somebody assigned in the current process to help guide the individual through the process. That is what this forensic navigator position is designed to do. And the forensic navigator is appointed from the very beginning. The statute lays out all of the responsibilities. Well, not all of the responsibilities. It identifies many of the responsibilities. You know, I think the language is including but not limited to, and then it lists the number of responsibilities of the forensic navigator. So this is really, really key to help make sure that the person gets to appointments, is engaged, understands what's happening. An examination takes place, just as Dr. Cranbrook was just describing earlier. And then once the evaluation is complete, the forensic examiner drafts a report, including their opinion about whether or not the defendant is competent or not. This slide, the last bullet point is bridge plans for misdemeanors. Bridge plans are also a key component of the new legislation. A bridge plan is a plan that is developed with the assistance of the forensic navigator. And it's a holistic plan about the person's mental health. Maybe it addresses housing insecurity. It may address job issues. And this plan is a written plan that is filed with the court when a case is going to be dismissed. And what this bridge plan does is, it really is such an apt term because it's a bridge to help maintain stability for this defendant, even though there's no case that's pending. Because when there's no case pending, if a case is dismissed, the court loses jurisdiction over the defendant and what happens. So this bridge plan, which can stay in effect for 90 days, is a way to ensure that a defendant still receives services, is open to receiving services. And our hope is that we can serve more people, encourage stability in the community. And of course, then what happens is it's all connected. If they're stable in the community, if they have housing, if we can connect them to a job, then they will be healthier. They won't commit crimes. Public safety is impacted. So bridge plans are a key part of this legislation as well.
And I don't know if you want to talk, Elizabeth, too, about the that one of the major issues with the misdemeanors being dismissed is that without somebody there to help a person, people would, it would be dismissed and then they'd just be back in the exact situation that they were. And I don't know what the numbers were, but, people would get new charges and then, some people, was it like actual dozens of misdemeanor charges over and over again?
Yeah, there was plenty of data which shows that in particular for misdemeanors, because under the current rule, when a defendant charged with a misdemeanor crime is found incompetent, that crime is dismissed. That can be things like, it can be a DWI, it can be a trespass, it can be loitering, indecent exposure, domestic violence. What we found is that because those defendants were not receiving services and they were just returned to the community without being treated, many of them re-offended on a pretty regular basis. It tended to be crimes like trespassing, theft. It didn't tend to be, I would say, the more serious misdemeanors like domestic violence. But there were people who would be repeatedly charged like 50 times, 40 times, and the system was not helping them. So the bridge, there's a question about what happens to individuals if they don't meet the terms laid out in the bridge plan. Nothing happens to them. That is a voluntary piece. There's no court jurisdiction over the bridge plan. If they don't meet the terms, they're not violated, they're not detained in custody. That is a voluntary piece that we hope people will take advantage of so that we can help them get stable and address their mental health needs. Are the services needed to support this new process fully funded? So funding, that's an excellent question. And part of this ties back to what Elliot said about the legislation passing at the last minute, literally, is that funding doesn't start until 2024. So even though this new process begins in 2023, in less than a year, funding doesn't start until 2024. The legislation is going to have to, the legislature is going to have to address that funding piece, because we're supposed to start this in a few months, in less than a year. So.
Yeah, and as far as building our mental health system or having affordable housing, those things I think clearly are not fully funded. And so that's just an ongoing, kind of battle for, advocating for those things to be funded. But coordination is a big piece also, so.
So part of the new process also includes different types of competence restoration programs, which is missing right now in our current process. The new legislation permits competence restoration, for example, to take place in the jail. So those cases that Dr. Cranbrook and Elliot were referencing where, and I think even in the chat, where people remain in custody without being treated, which is such a disservice, it's just wrong. This new legislation mandates that jails provide competence restoration programs. So that's going to be key. And I know Dr. Cranbrook can talk a little bit about how important it is to offer competence restoration services sooner rather than later. So having competence restoration programs available in the jail is really, really important. There are some individuals, for example, if somebody is charged with murder or a really, really serious crime, that is not going to be somebody who the court is going to be willing to release into the community. So that is why having a jail-based program is really, really important. There's also something called an alternative program, which is a program that may not be certified as a competence restoration program, but might include, for example, a substance abuse component, which might be a contributing factor to a particular defendant's mental health issues. And based upon the guidance from a forensic navigator, the forensic navigator might come to court and say, Your Honor, an alternative program might be a really good fit for this defendant because it appears that some of the mental health issues is prompted by substance abuse. So that's what an alternative program is. It is recognizing it as an alternative to competence restoration certified program, and giving, I think, some flexibility to the courts to deal with the different types of individuals that come through the system. There are community-based competence restoration programs that Elliot was talking about. There are defendants who don't need to be in custody, who can be served in the community. And this legislation recognizes that and identifies that as an option. And then lastly, of course, there's inpatient competence restoration programs, which is tied to the state operated facilities. It could also be in the community. So it doesn't have to be at a NOCA. It could be an inpatient secure facility that's in the community. Some of these facilities have to be built out. And, you know, we are hopeful and optimistic that the legislature will follow up on some of these options for treatment.
So in the most, so the forensic examiner who does the competence evaluation will also make a recommendation about what kind of restoration is needed. For the vast majority of people who are incompetent, it is a result of their mental illness. You know, they have, when they are at their psychiatric baseline or when they're doing well, they can understand the legal process, they could participate in their defense, whatever, but when they are acutely ill, they lose those abilities, or their psychiatric symptoms impair their capacity to rationally think about their legal case. And so for individuals, a subset of individuals, inpatient care may be necessary. So typically those decisions will be made based upon the acuity of their psychiatric symptoms, maybe their history of response to psychiatric treatment. Oftentimes the seriousness of the offense will play a role. So if individuals have, you know, charges relating to murder or attempted murder or a serious assault or something like that, it is more likely that they will end up in a more structured setting than someone whose charges are, you know, much less serious or violent. Once they are transferred to the hospital setting, the inpatient team has the, under the new system, has the right to determine if they're appropriate for care in that setting. So it's kind of a check and balance for the forensic examiner who made the competency opinion, and they will develop an individualized treatment plan for the individual. Now, since mental illness is typically the reason people have become incompetent, treating mental illness is not only what is appropriate for the individual, but it is also the biggest component for restoration of competence. So there may be a range of services provided in the hospital. There may be psychiatric care. There may be psychoeducational restoration programming, like about factual information about the legal system. There may be milieu therapies, other kinds of supportive therapies, but oftentimes psychiatric medications, treatment with antipsychotic medications is going to be one of the primary components of intervention. In the new system, there is a mechanism, because oftentimes individuals in our systems may have limited insight about the need for medication, or maybe opposed to taking psychiatric medications. And so there is a system within the hospital setting where the court can determine whether or not it is appropriate to court order psychiatric treatment. And there are a variety of sort of legal factors that get taken into account, but basically it has to do with, does the individual have a mental illness that can be treated with psychiatric medications? Is psychiatric medication the best way or the most appropriate way to treat the medication? Again, it balances on that risk. So in order to override someone's individual freedoms with regard to their decision about medications, there has to be evidence of risk to self or others that suggests that this medication is necessary to reduce that risk. With the new legislation, there is also one other prong available for court-ordered medication, and that has to do with sort of the state's interest in proceeding through the restoration process and resolving the criminal charges. And so does sort of the balance of the factors weigh in favor of requiring that the individual take antipsychotic medications, whether or not they want to. And all of this is also hinged on whether or not they can make a competent decision. So if people are able to make an informed decision about whether they want to take medications, then oftentimes that decision will be left to them. But many times that is not the case. In the hospital, someone's asking about medication affordability. In the hospital, I actually don't work in the treatment realm, but in the hospital, those medications are paid for. That is, of course, an ongoing issue for people going forward sometimes, I think. The plan would be that the individuals receive psychiatric treatment and milieu therapies and restoration services in the hospital and ultimately be prepared for discharge at such time that they are competent. An updated competence evaluation can be requested at any time in the process, and certainly for individuals who may appear to be stabilizing, or if it appears that they might never achieve competence, how do we make that resolution and sort of stop the cycle of people in and out of the system? Because competency is a separate construct from psychiatric stability. Some individuals may or may not respond to medication, treatment with medications. They may not, the opinion may not be that they can be restored to competence for several factors, or some people may be at their psychiatric baseline and still really not be competent to proceed. It's a small percentage of people, but that kind of thing can happen. So there are avenues for reevaluation of competence along the way and avenues for exiting the legal system if it appears that individuals will not ever be able to be competent to proceed with their case. I see a question about substance use disorders, and I do think that that has been one of the compelling reasons we've seen the rise in competence evaluations over the past couple of years, because more recent substances of abuse have got more long-lasting impact on cognition, psychosis, competence-related abilities, and the substances that were primarily abused in years past. And so I think there is the need to consider the substance use issues in conjunction with mental health symptoms. I can further read that question, but I know I'm aware of the time. So Elliot, maybe if you want to move on to your slide and I'll take a look at that question.
Yeah, and I think Elizabeth is going to talk about these legal pieces, or I'm happy to either.
So Elliot, why don't we both do this together? I'm just going to talk a little bit about this slide, which is the case law, not just our new statute, but case law requires due process for individuals in a competence restoration program. In other words, they can't be sent to a program indefinitely or indeterminately. There have to be periodic reviews on their progress. They have a right to come to court and have a judge review what has been happening. This statute complies with that due process requirement. Rule 2001 does as well, but it is a constitutional process. And what we learned, people like me who are not a forensic psychologist, what I learned engaging in this process, drafting the legislation, is that most defendants can attain competence within 90 days. And the statute provides for a possibility of return to court within 90 days so that people can, we don't have to wait for the 6-month return date, which is mandated in the statute. You have to come back to court in 6 months for the court to review whether or not you've attained competence. But it also provides for an earlier return to court within 90 days, because what we know from literature and research is that most people do attain competence rather quickly, anytime between 90 and 120 days. So that's a piece of this statute. And then the other piece is there is a separate provision in this statute about whether or not somebody is likely to attain competence. And the reason that this is an important part of the legislation goes back to what Dr. Cranbrook said, which is there are many situations which happen where a person is so significantly mentally impaired that the likelihood of this person attaining competence is really pretty slim. And right now, the process doesn't highlight those individuals for the court, but this new statute does do that. And it emphasizes to examiners, lawyers, and the court that we should all be on the lookout for these defendants who it appears are not likely to attain competence. And what the statute does is recognize that there is this class of defendants, and how should the court handle those defendants? It provides for possible dismissal depending on the seriousness of the offense with which they're charged. It provides for possible referral for commitment so that those individuals can move from the criminal justice system and obtain treatment. And it also provides for, depending on the nature of the offense, that the case will continue in the criminal justice system so that we can determine whether or not the person will attain competence. We rely heavily on the opinions and the guidance of Dr. Cranbrook and other examiners in assessing whether or not a defendant is likely to attain competence. But that's a separate standalone provision in the statutory framework, which is really important because, again, it emphasizes that there's this class of defendants that we should be paying attention to.
Yeah, and the other piece of the constitutional process is that there are just kind of stop gaps in place for dismissing charges. Like the original reason why all misdemeanors are dismissed right now, and in the new law, they'll still be dismissed, except for the, like Elizabeth said, like domestic assault or driving while impaired. But, the maximum sentence for a misdemeanor is 90 days, and this process takes usually that long. So there's really no reason to put a person with a 90-day sentence, potentially through the whole process. So that's why they get dismissed. But gross misdemeanors also have an end date, and it kind of just works where the prosecutors can say, I'd still like to pursue the case, and that gives it a small extension. But there are these hard limits on, whether how long can a person be in competency restoration programming before we have to just let it go or do something else. And it is based kind of tiered on the severity of the crime. So, felony, except for murder and other serious charges, are like 3 years that a person can be in that. And then it's just the very most severe ones are the ones where the court can maintain jurisdiction for the longest amount of time. I'll hopefully speak to some of the questions with the remaining time. One was about if there are diversionary options. That's definitely a consideration. And I think there was another comment too about it being, this is late in the process to address people with mental illnesses. And that's true. Absolutely. And that was a big part of the report the task force put together and advocating for. And there are other things happening in the legislature, in the whole system, to try and support these things. The forensic navigators do have listed as one of their duties to coordinate services to help people access treatment, housing, financial aid, and also pre-charge and pre-trial diversion. So the intention is for the forensic navigators to have that kind of therapeutic, holistic perspective, right? I think that is what they bring, is supporting the person through the process, and also acknowledging that, generally we don't want people with mental illnesses in the court system when they absolutely don't need to be. And so the forensic navigators are going to be hired and trained by this new board that was created, State Competency Restoration Board. It's similar to the Guardian Ad Litem Board, which just is appointed by the governor and the Supreme Court. So it has prosecutors, defenders, and I think one was required to be a mental health professional on this board. I think an important piece of helping to shape that narrative of, you know, being holistic in things is an advisory council to the board. So we're serving on that board. There's going to be mental health providers on that board. You know, the counties, county social services, lots of people are on that council, which is really going to flesh out a lot how the policies and procedures work, and certifying programs. And like we said previously, the funding is a little messed up, honestly, due to a clerical error. It's supposed to be 2024, but it was 2023. So the legislature may fix that, hopefully. Otherwise, there will just be, we'll work it out. We do have 3 minutes left. So if anyone has more questions, please feel free to ask. I also to speak kind of to the more broader context of how can we, you know, decriminalize mental illnesses. You know, these are NAMI's, some of NAMI's legislative priorities. So we are part of the Mental Health Legislative Network, which is a group of about 40 organizations, which includes advocates like us and providers, and really just, you know, people that were a network to present kind of what mental health community can agree on at the legislature. So you may or may not know there's 68 new legislators this year in the legislature. So there is a lot of educating to do. And so instead of bringing separate bills, the legislative network is actually going to bring just a series of bills that we all agree on. Because previously it would be like, well, this is a NAMI bill, and this is the providers bill, and this is, and so it could get quite confusing for new legislators. It gets confusing for veteran legislators. So, so we're going to have like an adult mental health bill, a children's mental health bill. So just to run through a few of those things, a big important point is that this whole process we just talked about does not apply to juveniles at all. It only applies to adults. There is a small working group with a lot of the same folks talking about the juvenile process right now and working on language. So that may or may not, you know, get fleshed out. This process, you know, took 3 years. So we'll see how quickly we could get something for juveniles. I'll say, I think that there is a lot of more openness to having like those restorative options and those kinds of things in the juvenile process. We have one bill just to make mental health related calls free from jail. Potentially we could hopefully maybe move that up to all kinds of calls, funding services for people that are getting out of jail, addressing solitary confinement, or what you might call disciplinary room time for juveniles. And then to speak to some of those systemic issues, you know, there's a lot of insurance issues right now with people talking about affording medication. There's a lot of barriers, you know, I won't get into the details right now, but there's also the rates that providers get to provide these services are very low compared to what they deserve to be paid. So building those things, building our workforce, which includes rural providers and BIPOC providers, and specifically addressing children right now with really complex needs, a lot of whom are boarding in the emergency room and don't have placements. We're really trying to expand what we have and also maybe create some new specific placements for kids like that. So that is our time. I didn't see any of the questions, but really appreciate everyone's time and attention. That's my email. I can connect you all to Elizabeth or Dr. Cranbrook if you'd like, but thank you all so much.
Thank you, everybody.